Hi, everyone. Thank you so much for joining us today. I'm excited to be in this session because I know that it's going to be packed with a lot of knowledge. So my name is Juliana Imam, and today we'll be talking about IP in the creative sector. Today, we are in the third week of the fourth quarter, and we have amazing guests, amazing mentors who will be coming to talk to us today. So I'll go ahead to read out what we're about for those who might not know. Sorry, hold on. Okay, so JIIPCC Mentorship and Internship Program is a quarterly intellectual property mentorship program for law students, young lawyers, and intellectual property enthusiasts across Africa. Mentees are afforded the opportunity to access valuable intellectual property advice, training, network, mentorship, internship, discussion forums, industry updates, and resource materials from experienced IP mentors. This program seeks to encourage continuous intellectual property training, development, and evolution in Nigeria, Africa, and around the world. Our hashtag is JIIPCC. You can watch our videos by searching for JIIPCC on YouTube and Facebook. Our objectives are to provide easy access to intellectual property guidance, training, and resource materials for students, young lawyers, and IP enthusiasts in Africa, to facilitate dialogue and network among experienced and less experienced intellectual property practitioners and stakeholders, to transform mentees into intellectual property mentors and leaders for the next generation of mentees, to facilitate further intellectual property mentorship, internships, scholarships, and IP-related for the mentees. So we're excited about today, and I would like us to listen and learn as much as we can. So our topic for today, as I said, is IP for the creative sector, and we'll be moving straight to call on the group leads. So I will be calling on Grace to continue the moderation for today. Grace, please let me know if you are here. Okay, please, you can unmute yourself. You're still muted. Hi, I can see that Alasta is here, Nosa is here, and I guess that we'll also be joined by Mandy soon. Yes, so we can hear you, Grace.
Okay. Good evening, everybody. I'm so sorry I'm late. Thank you, Miss Juliana, for holding in for me. Okay, so are we going into the group presentations now?
Yes.
Okay, so which of the groups is ready for their presentation, please?
Group 1, good afternoon.
Good, go ahead, please.
Okay.
You have 6 minutes.
Okay, is my screen visible?
Yes, we can see it.
So the topic for this week is IP for creatives. They'll be talking about the relevance of intellectual property in the movie and broadcast industry. So our introduction, the depth of relationship between intellectual property and the movie and broadcast industry is evidenced by the long list of credits at the end of the movies. If we notice, after the end of a movie, you see different lists of different people that so far that they can be accorded economic rights, at least their moral rights should be acknowledged. That's why we have most of their lists, most of their names at the end of the movie. So we go ahead to say, the film production is a complex and collaborative endeavor between several creators that give rise to different levels of intellectual property rights. So our presentation shall cover the scope of the movie and broadcast industry, relationship of IP in both industries, aspects of IP that are protected, the role of IP in both industries, and how filmmakers can protect their intellectual property rights. So before we go ahead, I just want us to watch this video. I think it's about just some minutes. So while we go ahead, I will relate back to the video later. The movie industry comprises of the technological and commercial aspects of filmmaking, such as writing, cinematography, animation, and film distribution. Filmmaking involves 5 different stages. We have the development stage, the pre-production stage, the production stage, the post-production stage, and distribution stage. A film could be distributed via home video, cinemas, Netflix, cable television, and so on and so forth. So we go to the scope of the broadcast industry. The objective of the broadcast industry is to inform, enlighten, educate, and entertain and disseminate the information to the public. This industry is comprised of all the media through which audio, visual, or audiovisual content are transmitted, and the person who facilitates the distribution process. Traditional forms of broadcast include television, radio, newspaper, magazine, social media platforms, and televisions. So what's the difference between and broadcast?
Baby girl, I'm in a class and I'm eating a bar. Hello?
A major difference between the movie and broadcast industry is that the former creates a movie while the latter distributes it. The movie industry creates the movies while the broadcast industry broadcasts the movie or whatever it is they produce. So both industries are interdependent on one another. They have to, like, one has to do it for one to broadcast. If there's no movie, the broadcast industry won't be able to broadcast that content. So I think without that broadcast industry, the movie industry will be able to put their movie outside for other people to watch. So they rely on each other for their commercial exploitation of their IP. How does it relate to both? How does IP relate to both the movie and broadcast industry? We say intellectual property relates to the movie and broadcast industry through different bundle of rights, which are protected by different law. We can use the Copyright Act and the Trademark Act. The bundle of rights under the copyright, we have the owner's right, the performance right, distribution right, adaptation right, and so on and so forth. While under trademark, we have the right to authorize other people to use it. So under the copyright, we say the copyright is the linchpin of the movie industry. That is the backbone. Most movie industry rely most on copyright because what they have to do deals mainly with copyright. The producer has the right to sell, to distribute, and broadcast the movie. The screenwriter has ownership rights. So the important people in that movie, most of them have each right. They have rights. They have like a copyright. If you don't have a copyright, you have like a moral right or an economic right. Each person has a right that you can later use and for incentive gain. So the songwriter who composed an original piece of the music of the movie or music as a copyright to that music. The movie is an adaptation of if the movie is an adaptation of an already existing work, the producer must have an authorization from the main owner of the work before you can go ahead to use the work. Now, when you talk about trademark, we say trademark also feature in the movie industry as long as it meets the requirements for registration. Now, when we say what are the requirements of registration, we are talking about it being distinctive and not descriptive. It shouldn't be deceptive. It shouldn't violate public order, and it should not be generic. And sometimes the trademark might be descriptive, but as time goes on, then it gains distinctiveness through use. We can give an example of KOB, that is King of Boys. It gained distinctiveness through use because we use it after a while, everybody knows that, okay, this name is particular to King of Boys. So that name, we can say it can be trademarked. Then when we look at the production logo, something like Rock Studio, when you see ROK, you know, oh, this is Merun Joku and her husband. So those kind of things can be trademarked for you to have an access, you have the authorization and the exclusive rights to use it. So the name of characters in movies can be trademarked, just like we have Aki and Popo or Sophia. Those names are particular to them. If anybody uses, you know, this person is not Sophia, so why do you have to use this name? So those names have gained distinctiveness through use after a long while. So we can say they can be trademarked. And that's just like James Bond and so on and so forth. Then we have soundtrack of a movie. So I'll give you a soundtrack that goes So that's the soundtrack of Super Story. It can be protected through trademark because everybody starts getting distinctive. They want to just hear it, you know, okay, this is Super Story. NCA has their own sound mark, and so on too. So we move ahead to the role of copyright in the movie and broadcast industry. What is the role of copyright in the movie and broadcast industry? We say copyright protect the creators, the movie producers, the singers, the media house from unauthorized use of their work. That is, before you can use a copyright owner's work, you have to get authorization to use that work. Without that, you can say that person is infringing on your work. Then the media company can, before a media company can use a copyrighted work, they have to obtain license, permission, or authorization from the copyright owner. Some of the rights granted to copyright owners include, but are not limited to, the right to reproduce, right to produce, adaptation, distribute. Then we can get other rights under Section 6 of the Copyright Act 2004. Then we'll move to the role of trademark in the movie and broadcast industry. Like I said earlier, we can use trademark to protect our movie titles, music album, and unique characters in a movie, like Mr. Ibu or Sophia, Jennifer Diary, Castle and Castle. These names are distinctive. Like once you hear Castle and Castle, you can't even think of what's happening in the movie. So that's the distinctive. In addition, it protects sound and animation that are unique to a company. For instance, the iconic roaring of the lion in the period of a movie is traceable to MGM. Just like the other video, the video I played first, if you listen to that soundtrack, you know, wow, this movie or this production is for these particular people. So a trademark creates a unique identity for filmmakers. It helps the public to distinguish the services of a competitor from that of others. If you notice before, you might not really know Jennifer as Jennifer, but when you say Sulia Kon, everybody knows that's Jennifer. So those kind of names can be trademarked because they are unique and they are distinctive to that person. So it increases the IP valuation of a brand. It is an intangible asset that can be sold or licensed. How filmmakers can protect their intellectual property? Every film begins with a script. So the script writer has a copyright on that work. Once you now like maybe license it or you sell it to somebody else, then you can still have a moral right to that work, while the economic right goes to the person you sold it to. You can obtain a license if the movie is an adaptation of an existing work. You conclude relevant licensing agreements with the scriptwriter and other relevant players involved in film production. When using digital media platform to broadcast your work, encrypt your work and use watermark on your work. Now, when we relate copyright to digital environment, it is so hard. It's so hard to claim copyright when you're on digital environment. So the best you can do is either you watermark your work or you just encrypt it. So people don't go downloading, because like what we all do, we all perform an infringement one way or the other. We download things every day without authorization. Is an infringement. Whether you give it out or you just put it on your phone is an infringement. So those kind of things, you can reduce it by encrypting your work, so people don't have that opportunity to download it freely without your permission. So we conclude by saying the Copyright Act is grossly inadequate in protecting the IP of filmmakers, particularly in the digital environment, like I mentioned earlier. So you will see some days, was it Katrina? She was on Instagram, was like, nobody should use her image without her authorization. So I think because we don't have enough backup for the digital environment, you just have to like protect your digital, your copyrights yourself. You find a way to protect it yourself. So traditional mode of broadcasting is slowly becoming unpopular among film producers and the viewing public. Then the Copyright Act will be amended to provide protection for works in the digital environment, like I mentioned earlier. Thank you for listening.
So I would move on to group 2. Who is presenting for group 2? Who is presenting for group 2? Yeah.
Good afternoon. My name is Johnny. I'm the one presenting for group 2. Please give us some minutes to share the screen.
Okay. Okay, so I think that you can start while you're waiting for the person sharing the screen to do that, or we can move to group 3 while your team works on the slide.
Okay.
So which one would you go with?
I think I would talk to the person sharing the screen at first, so group 3 can take over.
Okay, thank you very much. So let's hear from group 3. Who is presenting for group 3? Group 3, group 4, group 5. Okay.
Good afternoon, everybody. My name is Adam Somowenola, and I am presenting for Group 3. Thank you very much. So we are talking about IP for creatives in the music industry. Olamide will be sharing the screen. Has she started sharing the screen? Olamide, please share the screen before I start the introduction.
Good afternoon. Can't see the screen.
While you're waiting, please.
Okay. Like I said, we're talking about the music industry, intellectual property for creatives. So, like the previous presenter said, intellectual property is everything in the creative industry. It is your brand, it is your ideas, your client relationships. All these are valuable and they are worth protecting. So in this presentation, we are going to be talking about IP for creatives in the music industry, why intellectual property is relevant for creatives, intellectual property rights available for creatives, IP and the music industry, when does copyright start and end. Basically, it's giving us an overview of intellectual property in the music industry. Now, ultimately, intellectual property is everything in creative industries. IP law is complex, like we've been looking at, and we do not have adequate protection in Nigeria. It can be difficult to understand, but it should not be a barrier to protecting your business, your creative work. Getting the right advice is crucial, and it is important to have the right partner in moving forward. Day in, day out, creatives are faced with intellectual property related issues. These issues are stimulated by a combined effect of ignorance or minimal attention to IP as it affects the creative industry. And what is the result? And what happens when we don't have adequate protection? What happens when we don't have adequate laws or creatives do not take advantage of intellectual property rights available to them? This results into a spate of infringements and an avalanche occurs without adequate recompense. As Olamide started sharing the screen, oh my goodness. I guess I will continue since she's not available. Okay. Creatives devote substantial time and resources to enhance their output. It is only fair that they are accorded the legal protection to enhance their economic value. I mean, these people put a lot of work. If I'm writing a book, for example, let's use the music industry. If I would sit down, write a song, I would produce it, include the beat and everything. This is a process, and I actually deserve to be protected in the right way to enhance my economic value. IP protection is relevant for creative for several reasons. First of all, strengthening competition. Okay, like I was reading on Twitter the other day, they said scarcity breeds respect. So if you are a musician, for example, and everybody anywhere is just reproducing your work anyhow, it doesn't exactly give you a good competitive edge. Through IP protection, creatives can prevent their works from being copied or imitated by other people. Now, it also gives them an assurance of a fair return on investment made in protecting and distributing their works. So if we've seen the popular movie Squid Game, I'm talking about IP protection for creatives generally before we go into the music industry. That's why I'm using a movie, for example. So this point is, it ensures that they have a fair return on the investment made in producing and distributing their work. So I think 2 days ago, someone made a tweet and said Squid Game is one of the most watched TVs and the Nigerian market is highly influential in this. And then another person was like, is it the Nigerian market that downloads from illegal sites? So I do not know if they did not protect their property properly in Nigeria and why the infringement is so high, but then it doesn't ensure that they have a fair return on their market. These people invested money in producing the movie, but then we have people downloading from illegal sites that is in no way compensating the authors for their work. So if they protect their intellectual right property, it will ensure that they have a fair return on the investment in distributing their works. Then works produced by creatives are intangible assets that increase their commercial value and business proposition. So last week, my group discussed intellectual property valuation, and intellectual property valuation is one of the most important things that a business needs to consider, because it increases their commercial value as their work, their creative work is an intangible asset. Also, creatives can extend market reach by licensing or assigning IP rights for others at a fee. So in the music industry, for example, the record label, let's say Maven Record, can license out and give different websites and all of that to distribute and to exploit their work commercially. At the end of the day, other people are the ones doing the commercial exploitation, but the original authors are still getting compensated for their work. Then we move straight to intellectual property rights available for creatives. Now, first of all, we have copyrights. Copyrights are the rights to copy of any artistic, literary, or musical works. Copyright enables the author's rights to license, assign, or have full control over the distribution and reproduction of its work. Now, like we've been discussing since the beginning of this program, copyright is granted upon authorship. If I write a book or I create a song, as a songwriter, I write a song, immediately I write the song, I have copyright already. It is given by value of authorship. I do not need to register, although you register just to make the, should I say, the government know that, okay, this thing is available. But then upon authorship, I have copyrights. So copyright protects literary works like books, magazines, musical works. So at the end of the day, the most important intellectual property rights available for creatives are copyrights, because immediately you do it, you have protection. Then we also have trademarks. Trademarks is also available for creatives to protect their intellectual property rights. So a trademark is a sign which distinguishes the goods or services of one enterprise from the other enterprises. Let's take Maven Records, for example. That's a record label in Nigeria. So they have a sign. When you see that sign, you know it belongs to Maven, right? So this enables them to protect their artists. It enables them to protect the record label. And if you see this body of work, let's say a song, okay, no, you can't have that in a song. A music video, for example, and you see the Maven logo, right? You know that, okay, this belongs to Maven. I cannot just come up with a music video today and put the Maven logo because I'm not signed on that record label. So that is a protection for that brand, for that creative space. Then also we have trade secrets. Now, I don't really know about trade secrets in the creative space, but I think for the music industry, for example, if I have a special way I maybe make beats or mix and master, I don't know, and I want to protect that, I can actually register it as a trade secret. If one of the most important trade secrets now is the Coca-Cola trade secret. So what a trade secret does is a brand has a special way of doing something that distinguishes them in the market. So what they do is they protect that trade secret, they make their employees sign a non-disclosure agreement. So you working in that place, you cannot imitate that form, you cannot imitate that process to reach that output. I hope you get what I'm saying, but I don't really know how far trade secrets can go in the music industry. But like I said, copyright is basically the bedrock of the music industry. So we'll be moving straight up to intellectual property and the music industry. So intellectual property is what allows artists to innovate and be compensated for their work. As a music industry entrepreneur or artist, you need to know about IP and how it works. It is necessary to understand what they are and how they are relevant. Now, it is not just, okay, you need to know how they are relevant and how you can use it to your advantage. Although there are 4 major types of intellectual property rights, copyright is the bedrock of the music industry. I said that earlier. It enables music owners and creators to make a living and gives any author or owner of musical works the right to copy, that is, to reproduce, perform, adapt, or rework their own music. So Wizkid, for example, he owns this song. He can go out on and sing his music to the people. Why? Because he has copyrights by virtue of authorship. So the long time, I'll read a quote by a long-time music lawyer. Please let us listen, because I will just be reading, I will not be explaining. The right to authorize the reproduction of a musical or literary work with or without visual images, the right to authorize the distribution of the work, to rent or lend the work to the members of the public, the right to authorize distribution of the work or make it available to the public, is what copyright is in the music industry. As a copyright, you allow or prevent someone from doing all of this. That you can allow somebody to exploit the work to reproduce it to the public, and you can also prevent them from doing it, right? So music creators and owners earn a living by exploiting this right. I know we all think, okay, how do artists actually make money? Is it just by ticket sales when they have concerts or things like that? But then they do this by licensing the rights to exploit their creation. So when does copyright start and end? Like I said earlier, copyright is the bedrock of the music industry. So that's why we're looking at when copyright starts or end. Let's remember that I said copyright is granted by virtue of authorship. So as soon as you create the work, you have copyright. It lasts for life. As a songwriter, I have copyright to the song I have written forever till I die. And it does not only end there, 70 years after death. So that means my family members, for example, or my next of kin, or anybody that is succeeding me has the right to my work after 70 years if I die. Okay. So now we'll be going to the musical industry dynamics and copyright. So how exactly is copyright particular to the music industry? Music companies, related music organizations, artists, entrepreneurs, songwriters, and musicians, and also producers can all use the rights granted to them in copyright law to generate income from their music. They all manage, exploit, administer, and license their copyrights, and this produces income. So now we are looking at it from the point of view of a business. How does copyright affect the music industry? And in return, how do these people actually make money from exploiting their copyrights? So we'll look at four types of common copyright owners in the music industry, that is the major stakeholders. So first of all, we have songwriters or composers. Obviously, a song has to come from somewhere. If you use Apple Music, after a song, under it, you will see written by, you probably have 5 or 6 people that contributed to make that song a reality. So upon writing that song, these people have copyrights, right? Yes, so songwriters or composers create copyrights when they write music and or lyrics. Then more copyrights are created when they record the music. So that's the first one. If the artist that records the song, that sings the song, is not the one that wrote it, then the songwriter has copyright in that aspect. Then next we have musicians. Musicians create copyrights by performing on records. So there was this show I used to watch as a child, Austin and Ali. So basically, Ali would write the songs and then Austin would sing it. He would record the song under his name. So they shared copyrights in a way. I hope you understand in that way.
Mr. Rounding up. Thank you.
Yes, I'm almost done. Thank you. Then we have music publishers. Music publishers are businesses that work with songwriters, artists, and composers to manage their publishing rights in their copyrighted works. And the last one is record labels. Record labels invest in artists, musicians, artists, and producers to market their music and manage their mechanical rights in recorded music. I mentioned Maven earlier, so that is an example of a record label. They also have copyrights and they can exploit the intellectual property. So the last thing we'll be looking at is how creatives in the music industry can generate finance and recognition. So the first one is character merchandising, that is using their artists as ambassadors and all that. Licensing. Music licensing is simply the transfer of exclusive or non-exclusive rights to another person to reproduce musical works. Then we have assignment. Assignment is almost the same thing as licensing as well. And beat sales. So the record label, if they have producers, they can sell beats. So in conclusion, artistic works like songs and music are protected by copyright. A copyright is a collection of rights enabling the rights owner to be recognized and financially compensated for their creations. Also, the music industry generates income by managing, exploiting, administering, and licensing copyrights. And for the last one, like I've been saying since, copyright is the bedrock and lifeblood of the music industry. Thank you for listening.
Thank you very much, Omowunola Adams. Thank you so much for your goodness and your Jesus. Oh my God, sorry so much. Like my children are disturbing me, and that's the reason for my talking out of point. Thank you very much for your presentation. I really enjoyed it. So the music industry is an industry that is very interesting and is a place where I also started from. So I enjoy your presentation and I can relate to it. Let's move to group 2 and group 2, group 4, or group 5.
Yeah, this is for group 4. Group 4. Group 4, we are ready.
Please proceed, please.
Okay.
Thank you. You have 6 minutes.
All right, ma'am. Ordinarily, I'm not the person that's supposed to handle the presentation. I'm just to share the screen. So I'm still waiting for my colleague to pick up the presentation.
I don't know. My network is kind of bad.
Okay, so
Yeah.
if her network
Okay,
is
okay.
shaking, then you can take the presentation on her behalf.
All right, I think she's in now. Are you there?
If your group is not ready, let's allow another group continue.
So I'll continue with the presentation now. So good evening, everyone. My name is Usman Sadiq. So our topic for today is IP for creatives, focusing on visual works. So today we'll be talking about the following. We'll be discussing on who are creatives, then the meaning of visual works, then followed by why IP protection is relevant for creatives, and the types of IP that protects visual works. So to start with, I would like to talk about who are creatives. A creative is an artist. That is someone who sees the world a little differently than others. So creatives include painters, musicians, songwriters, composers, designers, photographers, actors, dancers, writers, film directors, cinematographers, and so on. So this list includes basically anyone involved in the production of literary works of an art. So whether in the film industry, the music, dancing, painting, design, lighting, etc. So works of creatives is one of the bedrock of IP protection globally. The creative industry is made up of sectors like music, film, dance, fashion, publishing, game, advertising, etc. So creative works are derived from the expenditure of the creative faculty of a person, while a creative professional is a person who is employed for the extraction of skills in creative endeavors. So now we'll move on to what are visual works. Visual works are works that can be seen, perceived, or appreciated with the physical eye. So it's something that we can only perceive, we can sense only with our eye and maybe our ear as well too. So that we can see clearly, maybe in form of image or whatsoever. So this may include creations such as drawings, paintings, photographs, films/cinemas, sculptures, or prints making, as well as applied or decorative arts and crafts. So all these examples, these are things that we can actually see with our physical eye. So in some contexts, it has been extended to include art created by digital media. So when a visual artist creates a piece of art, such art is a piece of property that can be sold, licensed, and exchanged for value. So a major volume of products in the entertainment industry comprises of visual works in film or cinema and advertising. So these include motion pictures and features, film documentaries, music videos, television shows, dance, commercial advertising, etc. So a network of creatives or creative professionals and creative management enterprises are usually involved in the production of the works that are distributed and consumed through various media. So now I would like to talk about why IP is relevant for creatives. So creative artists put in so much work and devote their time and resources to produce their work. So therefore, their work must be given the requisite legal protection and in turn enhance the economic value so that their efforts will not go in vain. So it doesn't make any sense for someone to, expend their millions or their time, their energy in creating a particular visual work, and it just goes to nothing when people abuse its usage. So therefore, the law has actually, give protection to some of these visual works. So IP protection of creative is relevant for the following reasons. So firstly, creatives slash artists are perpetually recognized as the author of their works. Yes, they have the right to that work as an author. So secondly, it prevents their works from being copied, reproduced, or imitated without requisite permission or authority. This is self-explanatory. So nobody can just move on to the work and, just copy or do anyhow with the work without their consent. So thirdly, IP provide exclusive rights, hence it affords creators of such works to recoup their investment expended in the making of the work. So all the money they've spent in the production of the work, they can actually get it back with the help of IP or legal protection. So also, number 4, it also increases the market value of their works and fosters competition. So this enable people to actually, be encouraged to actually, create more visual works, since they have the protection of the law, and they believe that their efforts will not go in vain. So also, creatives can also license us or assign their works, thereby generating another source of revenue. And lastly, when creators are rewarded for their works, it creates incentives for more works to be produced, giving room for innovations. So now to types of IP rights that protects visual works. So we have identified 3 basic types of IP rights that protect visual works. There may be others, but with these 3, we're actually within the scope of our research for this particular week. The following, the type of IP right as follow. Firstly, copyright, trademark, and industrial rights. So as we all know, copyright protects the original piece of work from being copied without permission. So the work must be the result of a person's skill, effort, and judgment. It cannot be something that already exists. So by owning the copyright, the owner has exclusive right to prevent or allow others to either copy the work, perform the work, make the work available to public through broadcasting or recording. And also, it also prevents others from making an adaptation of the work. So Copyright Act has comprehensive provisions on protection of literary and artistic work, not only on visual works alone. So another IP right that protects visual work is trademark. A trademark is a major or symbol used to identify the maker of goods or services. So this can be brand names, logos, or combination of both, as some of the speakers have earlier, pointed out. For example, now the Maven's record label, if you look at Maven's record, see that they draw a kind of this sphere, and they now use the capital letter M inside the box like this. So that's their own trademark. Many other company or entertainment industry also have their own trademark like that actually distinguish them from others performing similar or same work. So this can be brand names or logos. Excuse me, ma'am.
I said, please, you can start rounding up.
All right. I'm almost done now. So this can be brand names or logos or combination of both. So the mark needs to be distinctive in order to be registrable as a trademark. So as a visual artist, you may either be commissioned to design a trademark or have one to protect your own product. So the last one we have identified is the design right. An industrial design right is an intellectual property right that actually protects the visual design of objects that are not purely utilitarian. So a visual work or craft may consist of the creation of shapes, configuration or composition of pattern or color. So a combination of pattern or color in 3-dimensional form containing aesthetics value. Hence, these works of art may be registered as a design with the creators can enjoy benefit that accrue from protection of IP rights. So by way of conclusion, a piece of art may qualify for one or more of these IP rights. Yes. So for example now, like the visual work that we're talking about, it may qualify for IP protection or trademark, and even some other kind of IP protection as well. So also visual art creators should at all times identify the rights that exist in their works and explore all registration options to keep their works protected. So visual artist creators should also make a habit of keeping a history trail of evidence as to when their piece of work was created, e.g. posting a sealed copy to everyone and keeping it unopened. So keeping a log of all who came in contact with their ideas and when. So this will actually afford them the opportunity to have something to back up their arguments whenever they are to sue someone for infringement of their copyrights with respect to visual works. So this brings us to the end of our discussion on this topic. Thank you very much.
Thank you very much, man. Thank you for stepping in for your group member. So let's hear from group 2 or group 5. Thank you for the presentation actually on the visual arts. There are a lot of them in Nigeria now, so it's good that we know about them as lawyers so that we can protect them adequately. Okay, so I can see that Grace is here, so I think she can continue, but let's hear from either group 2.
Hello, can everyone hear me? Good afternoon,
Yes.
everyone.
Yes, we can hear you.
So, can everyone see my screen?
Yes.
Sorry?
Yes.
Can everyone see my screen?
Yes, we can see your screen. Go ahead.
All right. Good evening, everyone. I'm Hayatunde Abiodun, and I'm representing Group 5 today. And our topic for discussion is intellectual property and literary works. So first, an overview of how this presentation went. First, discussing what are literary works. Then go on to discuss intellectual property in relation to literary works. Then third, we discuss what is copyright, what rights does copyright provide. Then we'll also consider whether some works are free from copyright. And finally, we'll end by discussing some interesting facts about copyright. So to delve into it first, literary works include books, anthologies, journals, newspaper articles, reports, conference papers, computer software and programs, letters, emails, anything original, basically, like even short works such as abstracts, individual poems, dictionary minutes, or encyclopedia entries, all survives as literary works. Now, as to the intellectual property that relates to literary works, then the concept of copyright comes in. So copyright is the intellectual property right that is most relevant to literary works. And it's the legal concept that describes rights given to creators for their literary and artistic works, which includes like materials that I've listed out before at the previous stage. And an interesting thing to note is that there's no law that can protect an idea which has not been expressed. So copyright does not protect ideas. Ideally, it protects and reward. So I might have to like leave where I am. I'm sorry. So I'm sorry. So basically, there's no law that can protect an idea which has not yet been expressed. And copyright, the idea is that copyright does not protect ideas. It protects the ideas that are being expressed in some form before it can be subjected to legal protection. So basically, Copyright is generally owned by the creator of the work in the first instance. However, there are a number of things that that is dependent on, such as the type of work created or how the work was created. So also, an interesting fact is that a publisher will have to enter into a legal relationship with the creator of a manuscript or literary work in order to publish the work and issue copies of it in a sufficient quantity to satisfy the needs of the public. And basically, the publisher does this by virtue of a contract in which the author either assigns copyright to the publisher or more usually, it grants to the publisher an exclusive or non-exclusive license. Uh, Also, the publisher, in order to do business, needs to acquire from the author the exclusive rights of production and distribution. And these are recognized at the international level by the Berne Convention for the Protection of Literary and Artistic Works. And also, we have the World Intellectual Property Organization Copyright Treaty. And in terms of national legislation, we have the Copyright Act of 2004. So basically, copyright laws enable authors and other right owners to protect their contributions and to control or license the use of their work by others. So from all I've said so far, you can see that first, publishers must be familiar with the way intellectual property is administered in their country. Also, book publishers are licensees of other people's work. Although they can acquire copyright from creators through an outright assignment, they may also need to enter into publishing agreements with a variety of right owners, such as writers, artists, designers, photographers, picture librarians, and the rest, anyone with an original work. And these licenses specify what exactly the publisher is to do, and it defines any limits that be set by the right owners. So also I want to reiterate that to qualify for copyright protection, a work must be original. And an original work is one that originates in its expression from the author. That is, the work was independently created. I was not copied from the work of another or from materials in public domain. So I'll be going on to discuss some of the rights that copyright law provides. So first, it provides a right to reproduce a work in copies, to also distribute these works to the public, to also rent or lend copies of the work, and also, since by the internet age, to make the work available on the internet. And there are also two interesting rights. This is first, the right of paternity and the right of integrity. What the right of paternity simply entails is the right to claim authorship of the work, while the right of integrity is to object to any distortion, mutilation, or modification of the said work, which could be prejudicial to the author's reputation. And now I'm going on to discuss whether some works are free from copyright protection. And the answer is yes, some works are free. So the first instance is when you are using an aspect of the work it's not protected under copyright law. So that works too. Another instance is where you have anonymous works, when the identities of the authors cannot be determined. So that also counts. Another work that is free from copyright protection is the work created by the government. Now, we have this in some countries. The government will own the copyright to works created or first published under their direction or control. So, for example, in the UK, there's what's called the Crown copyright. Now, the last instance I'll be discussing is when the work is in the public domain. So once a work has gone its full legal term of copyright, then it will be said to be in the public domain and can be used, adapted, or published by anyone. So finally, I'll be ending this presentation discussing some interesting facts about copyright. So the first one is that a literary work can have multiple copyright owners. They will all have equal right to the material, unless there's an agreement in place. So for examples, in films, we have people who lay claims to copyright in the soundtrack, in the screenplay, in the film itself. and this right could be owned separately. Also, copyright ownership may be subject to legal agreements such as research, funding, or publishing agreements. And the interesting thing is that this right could be transferred or assigned to a third party. Finally, which is the last interesting fact of the copyright I'll be discussing, is the fact that copyright ownership is separate from owning the physical work or the literary work itself. So what I mean is that just because you physically own an item or a work does not mean you own the copyright in that item. So this is the thing: an author or a creator may sell you their work, but they will retain ownership of copyright unless you have made an agreement with the author or the creator to transfer such copyright. You will not own the copyright. That brings me to the end of my presentation. Thank you so much, everyone.
Okay. Thank you very much, Abiodun. That was a great presentation. Well done. So we'll move ahead now. I don't know if there's any other group that is still yet to present.
Yes, group 2 has not presented.
Okay, please go ahead. Please 5 minutes, all you have. Thank you very much.
Thank you. Okay, my name is Joy Johnny. I'm the presenter for Group 2, and our topic is IP for creatives in the fashion industry and dance industry. I'm sure the person sharing the screen will share.
Stop
the
sharing,
screen, but I'll
please?
just continue. I'll just continue without the screen sharing also. So first, we'll talk about the meaning of fashion. Fashion is considered as a form of art. It is also seen as the making of clothing, style, shape, appearance, and patterns. So fashion generally is the creation of styles and clothing. Moving further, I'll be talking about the legal gap. What do we mean by the legal gap? There is a need for intellectual property protection for designers in the fashion industry. So why is there need for it? That is what I'll be explaining. The economic and artistic contribution of fashion, very limited legal protections for designers, for fashion design are currently available. Although the fashion industry is fast-paced due to modern technology, images of the latest design are quickly disseminated online and into the hands of copycats, who immediately begin producing knockoffs and counterfeits. This makes it increasingly challenging for designers to achieve sustainable financial returns on their creative investment. So talking about the need for intellectual property protection, why do designers in the fashion industry need protection? This is because most times designers brand like Fendi, Gucci, and all are kind of not affordable to some people. So most times there is an increasing creation of counterfeit and knockoffs who kind of imitate these big brands like Gucci and all. So this is why there is need for intellectual property protection in the fashion industry. Moving further, I'll be talking about how intellectual property applies to the fashion industry. The fashion industry remains an increasing medley of intellectual property practice. Fashion law applies to apparel, footwear, and even accessories like handbags, glasses, and all. This emerging field of practice covers areas such as copyright, trademarks, service market, utility patents, design patents, counterfeit, trade secrets, trademarks, licensing agreements, amongst others. The fashion industry is, in most parts of Nigeria and sub-Saharan Africa, involves a lot of innovation and creation, so much that the owners of the labels give a second thought to the issues of intellectual properties. Intellectual property law protects fashion brands and certain elements of fashion design themselves. And the industry has recently seen increasing use of design patents, trademarks to protect their intellectual property rights. So due to the increased creation of knockoffs and counterfeits, that is why intellectual property protection is necessary for creatives in the fashion industry. So The available types of intellectual property creation that are available for the designers in the fashion industries are the copyright. We have copyright, we have trademarks, we have trade secrets, we have and so on and so forth. The fashion industry in most parts of Nigeria and sub-Saharan Africa involves a lot of innovation and creation, so much so that the owners of the labels gives a second thought to issues of intellectual property creation. The industry has recently seen increasing use of design patents and trademarks to protect their intellectual property rights. This type of IP vehicles protect the looks of a particular product or certain levels or certain novel design elements of such products. This means that intellectual property protection protects the looks of the designs. So, an example of a design patent might be an ornamental sculptural element such as an intricate bow affixed to a product such as a shoe or bag and all. So, a distinctive color scheme that appears on a particular brand product and creates an association between the color schemes and the brand also serves as a protection for intellectual property. In Nigeria currently, there is no specific legal framework governing the fashion industry, intellectual property in the fashion industry. That is why IP practitioners have therefore resorted to the general protection afforded under the existing legal framework. And this existing legislation for the purpose of protecting intellectual property in the fashion industries are the copyright, the Nigerian Copyright Act, the Patent and Design Act, the Trademark Act, and all. So these legislations kind of are the existing legal framework that serves as a protection to the creatives in the fashion industries. I'll move on further to the concept of dancers, IP for creatives in the dance industry. The concept of dance is seen as an art. Has been seen in various cultures across the globes and all. We have different forms of dancing like ballet, breakdancing, hip hop, tango, and all. So, the legal classification of dance. A dance performance consists of several creative elements which are protectable intellectual property in the form of copyright, industrial designs, and patents. Representations used by dancers can be protected as trademark and their identity under the publicity rights regime. Example of these representations are like maybe dancers like currently in Nigeria we have dancers like Pokoli and all. His name is Pastor Iwe, but his stage name is Pokoli. Is known as Pokoli. So that his stage name is like a form of representation and it can be protected under intellectual property. In Nigeria, choreographic work, a composition of dance moves, is deemed to be an artistic work and it is protected by the Copyright Act. The Copyright Act therefore automatically attaches to an original choreographed work, even without registering. It is, however, wise for professionals to register their moves in order to easily prove ownership in cases of disputes. Dance is protected as an intellectual property under the Nigerian Copyright Act, and this can be seen in Section 39 of the Nigerian Copyright Act. It defines choreographic work as a composition of movements for dancing or any other pattern succession of gestures, mostly created to accompany music. Now, how is dance protected under IP? For any intellectual property to be protected, it must qualify as such. Since choreography falls under copyright, it must satisfy the conditions of originality and be in fixed form in order to qualify for protection. Although copyright does not require registration, it is advisable to register dance moves to prove ownership. Now move further to the benefits of IP protection for creatives in the dance industry. The first benefit is that protection from indiscriminate use. It protects creatives creatives' works from indiscriminate use. The originator of the dance enjoys exclusive ownership to the use of dance, so others cannot use those dance steps frivolously. The second benefit is that it ensures economic reward. The owner earns more from his own intellectual property. So that is like another benefit of intellectual property in the dance industry. The third one is it encourages creativity. Protection of intellectual property, such as dance, encourages people to be more creative instead of copying others' work. It encourages creativity. Next, we move on to the challenges in the dance industry. That's challenges of IP in the dance industry. One is the ignorance of creators about intellectual property rights. Not most of the dancers, like in Nigeria and all, most of them are not aware of intellectual property rights. They are not aware of their rights as a creative in the intellectual property space. So this ignorance stands as a challenge to most dancers in the creative industry. Another challenge is that difficulty in enforcing legal rights. The process for enforcing intellectual property rights is through litigation, and this is a cumbersome process in Nigeria especially. So I move further to recommendations. The first one is creatives are encouraged to register their choreographic moves to ensure legal protection. Another recommendation is the use of alternative dispute resolution to resolve issues of infringement concerning intellectual property. The third is mass education for creating awareness of intellectual property rights. The public should be aware that yes, they have rights concerning their dance moves and all. So I move further to the conclusion. Fashion and dance are areas yet to enjoy full intellectual property rights protection, especially in Nigeria, which we see that currently there is no existing legal framework that governs the intellectual property in the fashion industry and intellectual property in the dance industry. The major limitation is the uncertain legal framework in this regard. It is expedient to develop legal framework to ensure the protection of intellectual property in the dance and fashion industry. Legal practitioners and intellectual property law experts, the legislature that are concerned with this area should work together in achieving this. So I think that is all from our end. Thank you for listening.
Wow, okay. Thank you very much, Joy, for that presentation. That was great. So right now we'll move on to presentations from our mentors. So our first mentor today is Mr. Alastair. I don't know if he's ready. Hello, sir.
Hi.
Okay, so it's your turn now. Thank you very much for joining us. You have 10 minutes, sir.
Sure. What would you like me to cover? Would you like me to talk about some issues raised and some interesting points raised by the groups, or do you want me to talk a little bit about what I do, or a mixture?
Yes, you can. Were raised in the group. Thank you.
Sorry, I didn't hear that.
You can talk about some of the issues that were raised in the group that you would like to elaborate on.
Perfect. That sounds good. Can I firstly say well done to all the groups on their presentations. I found them really interesting. I thought you all presented very well, very eloquently. It was clear that a huge amount of work had gone into this. So I should first say congratulations. I found them all really interesting, and I thought you all did an excellent job, both with presentations and with the content that you covered. By way of background, I know my kind of biography probably gives a little bit of information, but I'm a film and television lawyer. I originally worked at a big city corporate law firm, and then I moved across into the media and intellectual property world. And I work in London as a UK qualified solicitor. I generally advise production companies on commercial IP contracts within the film and television world. So quite a few of the issues that you raised in your presentations are very relevant within the film and television world. So I thought I would pick up on a few interesting kind of practical points that were made. and one of them relates to Group 1, who talked quite a bit about film and television and intellectual property. And you're absolutely right that IP is at the cornerstone of, and copyright is at the cornerstone of film, and protecting that as a creator, and whether that's a creative writer, a director, or indeed a producer, is very, very important. And one of the, I thought, very interesting things that you raised at the end of your presentation was how practically you can protect your IP. And that's an interesting point, particularly, and I get the sense, and I'm obviously not a Nigerian qualified lawyer, but I get the sense that there is concern from creatives within Nigeria, perhaps, about the extent of the Copyright Act in Nigeria, and about how you can, make sure you protect valuable IP, and how creatives can protect IP. And so I thought those practical commercial points about encryption, for example, about watermarking scripts and watermarking copywritten material are very important. And the other point I want to raise is, as lawyers, which I'm sure you guys will all be aware of, but a lot of creative individuals are not, is signing agreements without proper advice. And that really is the value that lawyers have, and that many of you may have when you fully qualify in due course, is there is a kind of tendency to just present a contract without the creatives fully understanding what's involved, and needing to be very careful about particularly language around assigning rights. You shouldn't be, creatives should not be simply assigning all their rights in something, and in their valuable creative work, unless they fully understand what they are doing. Because there's a real danger otherwise that they lose, the valuable IP to which they have created. Another really interesting point, which I thought you kind of touched on, is the extent that copyright actually protects, because you are right that it's got to be original identifiable material, and you can't, that there is no copyright in an idea per se. So there's quite a lot of case law in English law around can you protect a television format, the structure of, can you protect the X Factor, for instance? Can you protect a format for a TV series? And it's an ongoing kind of legal discussion, and there's quite a bit of case law in it. But in short, not definitely is the answer to that. There is reasonably limited protection for protecting a television series format directly. There's no kind of copyright certainly in the UK doesn't recognise an idea or a format. And so I think the big thing about this is, if any of you are asked to advise creative friends or people within the industry, it's to write stuff down. If you have an idea, if you know somebody who has an idea for a television series or a script, they should be writing it down, and not, that really is the first, most straightforward way of beginning to protect yourself in terms of copyright. So encryption, yes, absolutely important. Asking people to sign non-disclosure agreements, that's another good practical way of protecting oneself in terms of copyright, but actually more straightforwardly than that, writing the idea down in as much detail as you possibly can. And it's something that I say when I'm representing producers who I look after, and they have come up with an idea for a project, the first thing that I say to them is, well, make sure you write it down. That's the first thing you should be doing in as much detail as you can, because if you just talk that idea through people, you've got no evidence for what your copywritten material is. Whereas if you write a 2-page summary of a story, even if you haven't written a full script, that is then copywritten material. I thought you touched on a really good point towards the end of the presentation there, and I think that applies not just in film and television, but also in, you know, protecting literary copyright, you know, as Group 5 suggested. Now I know one of the other kind of a few people have raised queries about what about the rights in a dance, for instance, or what about the rights, you know, where do the rights sit in terms of when you do film material? And I think one of the interesting things to say on that is, you know, under UK law, under English law, the director and the producer own the rights in any film that you, you know, that you produce. However, that raises an interesting point for a production company. So if you're a production company and you create a film and you want to sell that film, or you want to license the right to that film to a distributor or a broadcaster to produce, you actually need to make sure, if you're the one entering into that contract with a broadcaster or a distributor, you, the production company entering into the contract, need to make sure that you take the rights of the director so that you can enter into that contract. So whoever is going to license the rights for your film needs to make sure that anybody who contributes to that film or anybody who performs in that film has licensed or assigned their rights into the entity who is going to contract with any broadcaster or distributor. So that's even if the automatic position under law is that those rights might sit with a director, or the rights in your performance, if you're an actor, might sit in you. You, as whoever is contracting and selling that film or licensing that film, needs to make sure that they are that they have been assigned the full rights. So I think that's a kind of a useful point to make clear. So I think in terms of specific kind of thoughts that I had or you know, points to raise, those were the key ones. But I don't know whether Juliana or anyone had anything otherwise that they would like to ask me, and I can always have a go, or my time might be up in any case.
Okay, thank you very much, Alastair. So I think maybe we'll just wait until the Q&A, and then you can answer some extra questions that we might have. Thank you so much. Thank you so much. So back to you, Grace, so we can move on to Amanda.
Okay, so I think we should move to the next mentor right now before we can take the question and answers, right?
Yes. So we'll just move to Amanda. Amanda Unoma Uzwaba.
All right. So Miss Amanda Noma Uzoba is an entertainment lawyer. Give me a second. She's an entertainment lawyer, a creative. Sorry, my screen is no longer visible.
Okay. Sorry, I wasn't sure you wanted to read it.
Okay.
Okay. Because of the time, she's about to leave for another event, so we're just trying to rush so that she can quickly speak.
Okay, so do I have to go ahead with the reading or she should just continue?
She can continue.
Okay. Mayoron.
Hi, thank you, Gianna. Thank you, Grace. Good evening, everyone.
Good evening.
Okay, so I heard some of the presentation and I wasn't able to be around for most, but I think a few things I want to mention was I don't know the group that talked about trade secrets. I was talking about that she wasn't sure how it's applied in the creative industry and all that. There are certain media companies that you work for that after working in those media companies, you can't work in any other media company within that vicinity. And that's all in their bid to protect their trade secrets. So it goes beyond just signing an NDA. For example, if you work with Pulse, when you're done, you cannot work in any similar company like that for a period of time, not like forever. So you could end up working for a particular media company that will tell you, okay, you can't work with any other company within that area for 3 years or for 4 years, or you cannot go into such business. Then after those 4 years, once that restriction is off, you can go on. And that's all because they're trying to protect their trade secrets. Because even if I don't intend to share it, I may unconsciously use it because it's something that I've learned while working in companies, something that is already in me. So in order to protect their competition and protect the little market they built for themselves, they rather have you employ those abilities or those information you might have, not really saying anything in another atmosphere, in another country, in another space, or in another industry. Then also, the person that talked about dance, saying it's an artistic work. If you read your Copyright Act, you realize that strangely, choreographical works was mentioned under literary works, not artistic works. So, which is one of the things that make us insist on the fact that Copyright Act is not that useful to us. It's just what we're managing to keep the industry on one piece till we have something better. So strangely, yes, you can find the definition of choreography in the definition section of the Act, but where it's actually positioned is under literary works, not artistic work. That doesn't mean that it cannot still be protected. It just means that you have to go through a different route of protection than the normal, it's an artistic work or me making a video and presenting to register it. But is it possible to register a dance? Yes, it is. The person that also presented on music, the person tried, but when you leave that space of academics and come into practice, you realize that some things are actually different. You realize that your Copyright Act and everything you're learning in intellectual property tell you whoever created the song is the owner of the song. But in practice, it's not. It could be the person paying the song. It could be someone that doesn't even have any stake in that song, but just because somebody signed the mistaking the rights over to that person, and he or she ends up being the actual owner of the song. So you might end up seeing credit loads under a Spotify music or something that this person wrote the song, this person wrote the song. Doesn't mean the person is any 1 naira that's coming from the song. Doesn't mean that person is recognized as the author of the song. The person just recognized as a contributor to the song. If any decision is going to be made on those songs, it's whoever actually has the rights to the song, which could be the music exec, it could be the record label, it could be a sponsor. At the same time, it could be the artist. At the same time, there are situations where music producers also own their rights. It's just that most of them really don't care. They prefer to just take the money and go in the first instance. So, like I said, I didn't really listen to all the presentation. So if there are particular questions I can answer, then I think you can just throw it on and I'll answer it.
Okay, so the questions are in the chat box.
Okay.
So you can just go through them. If there's anyone that you think you want to answer, you can do that.
Okay. I'll just take a few. In a record label, who owns copyright for the song? by an artist. Like I said, it depends. So naturally, like you already know what the law says. You created the song, you own the song. So on a normal day, if 3 people created song, maybe one person was music producer, the other person was the songwriter, and the other person was the artist, then the 3 of them own the song. That's in a typical world. But then, like I said, there are situations where a recording deal that is already signed by the artist has already stated that all songs created by the artist is automatically and exclusively assigned to the record label, and that record label are the only owners of that song. And such deals can be, I won't say they are bad, but definitely when you're signing deals, you have to give record label that license and that power to exploit your song for the good of you and the record label. But if you're going to assign your rights to a record label, then there should be a reversal clause, literally saying that after a period of time, maybe upon the contract ending, or 10 years or 5 years after the contract ends, the rights are coming back to you, or parts of the rights are coming back to you. So in typical world, like I said, it's the artists and the contributors that own rights to the songs. But then if things are not like in typical world and you sign out your rights, then it could be any other person that you sign the rights to. In a licensing, who gives the authority to reproduce songs for commercial exploitation? The producer, the artist, or the record label? The record label has business with dealing, like record label deals in the business of the music. So the way it's supposed to be structured, or the way it's structured, is that all the artist has to care about is making the music, then understanding the business. So when it's being explained or things are being done, you understand why things are being done. Why is the business of the record label? To ensure that the music makes money. So another person that you didn't add to that group of people that could give rights is distributors. If you have a distributor, if you sign a distribution deal, then the rights of is the obligations of those distributors, distribution company, to ensure that the music is placed in places that is going to bring money, including giving permission to put your movie, or sorry, to put your music in a movie. Now for a record label, if you assign rights to them to do that, yes. If you give power of attorney for them to sign even without asking you for consent and all that, yes, it's possible. Producers, there are hardly situations where producers have rights to say, okay, I want this song to go on this platform or not, except if it's like a producer called, or it's not really like a full song, or maybe instrumental belonging to the producer alone, then yes, he can do that. Or if within his split sheet, he actually holds back a little power, saying that, okay, before this kind of contract is signed, before licensing permission is given, my consent needs to be sought. Then in such situations, then yes, he might have a say in who gets what. Is image rights enforceable in Nigeria? Yes, to an extent. So basically for image rights, we have one case that kind of, I would say they won that case on the power of the fact that one person was really, really popular. So it's basically, what's the word? Trying to remember the legal term for that, or like where you're popular and you're riding off on my reputation and my popularity. So there's a case, Norma and Nosike and Wema Bank, where is kind of a benchmark for image rights to an extent. But do people actually go ahead to sue? The problem is not that is there any rights, or rather is there any law or any provision or any case in support of it, is do people actually take it that seriously? So we have one that can stand as a benchmark in case tomorrow you want to, like at the end of the day, she got, I think, about 10 million in awards for damages for that suit. And then it's basically about image rights because she did a photo shoot. She's a Nigerian model in New York. She did a photo shoot here in Nigeria, and the photo shoot was supposed to be for something, and the photographer gave the pictures to Wema Bank and they used it for advert, and because of it, her modeling agency dropped her because they thought she was doing business with Wema Bank behind their back and all that, and she sued and she won them, and she got about 10 million, I'm not sure, but about 10 million awards. Okay. I'm just trying to find. Her dances on social media handles like TikTok copyrighted. I don't know if they're copyrighted or they're copyrightable. So you might know this savage dance that went during the pandemic, the popular TikTok routine to Savage by Mega Stallion, and the ladies that created that dance steps or that dance routine eventually registered it. And the news came out, I think, I put on the podcast that I had, that was July. The news came out around May, June, that they had registered it, twins and another lady. So 3 ladies. It's possible for you to register TikTok routines, especially if there are a couple of dance moves that you put together, you get as a proper routine. Now, the issue now is that, for example, in US and some of the foreign jurisdictions, if you allow a song get very popularized, or rather a dance that get very popularized, you might not be able to register it because there's a category known as social dance. And social dance are like dance steps or dance routines that people are very accustomed to and people have learned and everybody's dancing it, like it's out there. And then it's seen as, like, let me not use the word public property, but you cannot really like claim ownership over it. So if you allow your dance routine trend that much and it gets to that extent when it's not seen as a social dance, you will not be able to register it. You can just take extra steps to maybe brand it and make the world know that you are the person that created the dance step for the sake of getting more business in the future, but you might not be able to fully protect it under copyright. Now, does that apply to Nigeria? I'm not sure, because when it comes to Nigeria, when it comes to Nigeria and dance industry, was still very, very, very backwards. So I wrote a book on legal aspect of dance industry, but when I did that, I realized that we didn't have anything in Nigeria. So it was basically a stitch up with what our legislation is saying, what it is in the foreign jurisdiction, and what we hope it is going to be tomorrow. So if you want the book, you can hit me up and get it. In what ways can script writers or movie producers protect movie characters in Nigeria? Truthfully, it's possible, but in practice, they don't care. That is fact. Even as far as, oh, how can they protect their script? They really don't care. So everybody just wants what? Either to buy the scripts, make the money from script and move on. Now, is it possible for you to protect the character? Yes, but I see that applying more in the animation industry than actually in Nollywood and general industry. Because then when it comes to the animation world, they are, which I'm still learning about, I'm not really like that vast about them and seriously still learning about them daily. But I've come to understand that different people partake in creating what we see. So one person might be in charge of creating the characters, and the other person is in charge of creating the universe, and the other person is in charge of creating the stories and all of that. Now, it's possible for you to register or rather protect characters based on their names, or maybe, will I say, their actions, but their actions will still be under maybe literary works. You write down something and you say. Now, the bits that can do for you is to give restrictions on those characters being used in the movie. It doesn't stop the movie from going into play, because then I might as well decide to switch characters and use a different character. So that's why when it comes to the movie industry itself, when it comes to Nollywood, it's not really that practical, and they really don't even care about it. The most they can do is maybe copyrighting their name, try to trademark if there's anything in like absolutely distinct about those characters. But truthfully, my dear, let me just tell you the truth, they don't care about such. Their mind don't go to that. Is there any overlap as with copyright and trademark in the movie and broadcasting industry? I don't know what you mean by overlap with copyright and trademark. If you can clarify that question, then yes. I think I can answer one more question before I leave. What challenges do IP owners in the fashion industry face? I would say, one, the registration process is not that fast. You know, this is Nigeria, every trademark takes forever. So industrial design protection takes time. Two, the industry is not yet there. So forget, when it comes to legal aspect of things, I would say the music and movie industry is forefront. The fashion industry is not there yet. At most, they think about is trademark registration. but no one goes as far as industrial designs, as far as protecting the actual designs. Now, I've seen some brands go far and beyond to protect, but those brands, if you look at them, they have, like say, they have international ties, or they believe that they are big enough for them to do that. So I would say some of the challenges they are facing is lack of knowledge. The process for now is still, it takes a lot of time. The process is not tedious. Good enough, you can register like 50 designs at the same time, which you can't say about copyright. So on that aspect, they have it easier than other people. What other issue will I say that they have in the fashion industry? I don't know whether there's any other challenge. Well, when it comes to legal aspect, they're not there yet. For now, it's just all fun. Maybe, hopefully with time, they'll get there and we'll catch up with them. So I think I'm going to be signing out. Any other questions before I leave?
Thank you very much, Amanda. Thank you for your time. Thank you for sharing, and thank you for staying, despite the fact that you have a meeting. Thank you so much.
Thanks for having me. All right.
Thank you. Okay, so we'll just move straight to the third mentor for today. Grace, over to you.
Mr. Nosa, I don't know if he's still on. Let me check. Yes. Sir, if you're available, we're ready for you now.
Yes, I'm just about still here. Can you hear me at all? Can you see?
Yes, sir. We can hear you.
All right, I'm just about still here. I was supposed to be in another meeting at 6. But
so sorry for the time.
It's fine. I mean, I must say I really did enjoy it. I don't know if you guys can see or hear me at all.
Yes.
Yes, we can see you.
Can you see me? Am I visible?
Yes.
There's no screen.
Yes, sir.
Let's see. Let's see if I can see. Okay, can you guys, okay, I think okay, you can see me now?
Yes, we can see you, sir.
All right, brilliant, brilliant. No, I was just going to say, firstly, I think there were great presentations. There's a lot of information from different people. I think, they were kind of rushed as well, but I understand, the program and stuff, you're given like, 6 minutes or something to present what you have. So I think, they did really good under the circumstance. In terms of answering the questions, I think Amanda has answered all the questions, to be honest. She did a great job at it. So in terms of, I think I'll probably just mention a few things that I probably noted in some of the presentations. I might double on a few things that both Alistair and Amanda said, because they were great. Again, they've already, giving great feedback and stuff. But I think, yeah, I'll just do one or two things. First, with regards to, someone asked a question in one of the presentations, if it was possible to copyright a film title. I can remember one of the presentations, someone said that, and I think it was one of the questions as well. And the answer to that simply is that it's possible, but it's not effective, okay? It's not effective simply because film titles are not unique in themselves. And so, for example, there are so many film titles with the same title, if that makes sense. We go from the classic Bad Boys with Will Smith and Martin Lawrence. There is another film called Bad Boys. There's The Asylum. There's 2 other movies, called The Asylum. There's Crossroads. There's just so many. I even have a movie that I am an executive producer on called, what's it called again? The Accidental Spy. Now, if you Google The Accidental Spy, you see the movie by Jackie Chan, okay? Well, there's another movie called The Accidental Spy with AY and Co in Nigeria. So it's literally the same title. Okay, so what I'm trying to say is there are so many movies, hundreds of movies out there that have the same title, okay? So it's not effective because titles in themselves, and I know someone said that there was a movie called Castle and Castle, which I know is a Nigerian movie and stuff, but you know, and whether that can be copyrighted. You can, but the truth is, someone else. You hear me?
Yes, I can hear you.
Someone else in the next 5-10 years can come up with a movie called Castle and Castle, you know, and you know, and you know, they won't be infringing on anything basically. So just, you know, just to get that in. So what I'm trying to say is it's possible, but it's not as effective. I think the other thing someone was talking about was trade secrets. That's it. The presenter on the trade secrets talked about, I think it was Joy Johnson. She was saying, no, so it wasn't Joy Johnson, sorry, it was, I can't pronounce her name, Mawu Lola or something like that. She said something about, she didn't understand trade secrets in the music industry, or if it applies to the music industry. So just to answer that question, it does apply in the music industry, but it applies more to B2B aspects of the industry as opposed to artists, okay, as opposed to creatives. It applies more to businesses. So for example, you have all the startup companies like the tech companies, the DSPs, the companies that create music technology, for example, that help artists either distribute or create or aggregate or whatever it does. So companies like that, and I think Amanda made reference to something like that earlier on as well, that I think she gave the example about with Pulse, which I believe is a media network in Nigeria. If once you work for them, you'd be restricted from working with a competitor. Similarly with a lot of startup companies, music tech companies. And so, yeah, that's how trade secrets can apply to the music industry. And then I think there was something else about, I think Amanda also answered that question with regards to whether dance on TikTok can be protected. And I think she answered it well, yes, that the Savage Challenge dance, which was created by Kira Wilson, was filed in the US patent office, and she got her protection on that. And it's a new area, okay? I must say, because TikTok and social media in general is a new area, there isn't much legislation protecting creators in this area at the minute, okay? In the UK and the US, they are always pushing bills through and trying to create new legislation to protect creators in this new era. I think they're really slow in doing that in Nigeria. I am aware, because I have dealings with some Nigerian practitioners, I am aware that even the copyright bill, the Nigerian copyright bill, is due for an amendment, and it's been sitting in the House for years, and they haven't, you know, pulled their finger out in amending it yet. There's been so many bills have been put through, and so I think we need to remember that when it comes to TikTok, when it comes to social media, when it comes to the area of creativity, it's a new area. And so as much as there is no direct protection in law, there are other ways in which you can protect yourself. And I think Alistair was mentioning some of them as well. You know what, write your creativity down, you know, and use other avenues, other pieces of legislation to protect your creativity. I think that was, I think there were some other things that I can't really remember now, but there were some other things. Again, fashion, sorry, let me jump on fashion again. Fashion law in the UK is not, there aren't so many fashion law firms in the UK compared to the States, okay? There aren't a lot. And there's only probably just one school that teaches fashion law, okay? And I think there's even London College of Fashion. They have a module on fashion law. The traditional universities don't have modules on fashion. So again, you know, fashion is, and the funny thing, fashion is not a new area of business. It's not like social media. Do you understand? Which in the last 20 years, social media is, you know, fashion has always been, we've always had fashion and stuff. But for some reason, fashion law kind of falls on the other areas of law. So you get protected basically through other areas of law. And I think one of the speakers, I think it was Jo Johnson this time, she gave an example. She didn't mention it, but I saw it in her slide, the case with the Louboutin and Eve YSL. I think that there was a case study, or at least a case example that she mentioned that she highlighted in her presentation, which is a very good way to do a presentation. I was actually going to say, sorry, can everyone still hear me? I feel like I'm frozen.
Yeah, we can hear you.
We can hear you, sir.
I was going to say, it's actually a good thing to always throw case studies in your presentations. I mean, it's one thing just, reciting the law, and anyone can recite the law or go and research the law. But one of the good things I liked about some of the presentations was that there were case studies. I know a lot of people were making reference to Maven when talking about the music presentation and stuff. There again, Maven are the biggest record label in Nigeria. But also look at other record labels, because there are case studies in other record labels. There have been legal issues or disputes with other record labels, from Chocolate City to YBNL to The Works. So look at other record labels and organizations as well, or individuals as well. So for example, there was a case between, I think it was Simi and Sir Victor Wifo on the track Jeremy. If anyone remembers that one, there's so much litigation coming out of Nigeria. There's so much that even we can't even keep up. But again, it's understandable because the creative industry in Nigeria, again, is young. Okay, it's young in that, yes, they've been there from decades, don't get me wrong, but this new generation of creatives, okay, are just coming out of the woodwork now, and all of a sudden they need to be protected. All of a sudden they need to know and understand their rights. People are just doing things without the right understanding of what they're doing. So for example, going to studio with my friend, he's my mate, we do a track, we do it, put it out, forgetting to, complete split sheets, forgetting to sign documents, forgetting to do the registration process of your works. And then the track becomes a hit, and then there's a dispute. Yes, it's a young industry, the Nigerian music industry, but the copyright law in it is archaic, is old and needs updating. But I think, a lot of educating people, awareness of rights and things like this, I think this is really good. I think what you're doing, guys, is really good. I think, I'm not trying to put span in the works, but doing a presentation, maybe one presentation a day, to a wider audience would really be good. I think a lot of people that would benefit, especially from the fashion talk, the dance talk, the literary works talk, the film talk, the music, a lot of people will benefit from it immensely. I mean, I have conversations with people every day, both in Nigeria, in the States, and in the UK. So I think what you guys are doing is really good, and I think you guys should keep it up. Unless you have any other questions for me?
Yes, sir. I think there's a question about if there's an overlap between, just give me a second. Is there an overlap as with copyright and trademark in the movie and broadcasting industry? That if there's an overlap between copyright and trademark in the movie and broadcasting industry. I don't know if you can throw more light on that.
If there's an overlap between say that again, sorry.
Is there an overlap between copyright and trademark in the movie and broadcasting industry?
You're going to have to say that one more time. Just say that one more time.
Is there an overlap between trademark and copyright in the movie and broadcasting industry? Like, is there an overlap between trademark and copyright?
Well, the question is there an overlap between trademark and copyright in the movie and broadcasting industry? Is that your question?
Yes, sir.
Yes, there's definitely an overlap. I think Alistair talks on that quite a lot. Alistair talks on that quite a lot. Now, Alistair specializes in the movie and film industry. I don't specialize in that. I just have business in that, if that makes sense. So but he specializes in that, but there's definitely an overlap. I specialize in music, okay? I specialize in music and others, but he does a lot of the movie and the film. So I can't really, and I don't want to give wrong information on that, but there is an overlap, yes.
Okay, there are some questions in the chat box, so maybe you can look at them if there's anyone that you feel you still want to touch on, or if you think that you answered all of them already.
Right, give me 1 second, let's go there. Is it all the questions in the chat box? I think Amanda answered all of them, but I can go over a couple of them again. The answer to the first question.
You can just check for anyone that you think you would like to add.
Okay. In a record label, who owns the copyright for the song? Okay, so Amanda answered that, but I mean, I'll just add to that and I'll say, there's a rule of thumb that we use on that question, who owns the copyright? The rule of thumb is really, whoever pays owns, okay? Well, he who pays owns. And so if the record label pays for the production, the creation of the work, technically they'll own it, at least for a season until it reverts back to the actual creator. If an artist is not signed to a label or whatever, and he's doing his independent and stuff, and he pays the producer and stuff, he goes to the studio and he creates stuff, he owns basically the copyright, okay? So technically the rule of thumb, if you're ever in doubt, is he who pays owns, okay? The second one, in the licensing, who gives the authority to reproduce the song's commercial? Okay, I think Amanda again answered that question. And it's really the creator, but let me rephrase that question. In the licensing, who gives the authority? Well, the licensor gives the authority, okay? In a simple way to answer that question, okay? He who owns the copyright gives the authority, gives the license. The word license is another word of permission, okay? I'm giving you permission. I'm giving you a license. I'm giving you authority to exploit my works, my creativity, to reproduce, to duplicate, to, you know, get it in movies, synchronization deals and stuff, to get it in, you know, on billboards or whatever, just, you know, do whatever you want to do with my music, you know. So whoever owns the copyright gives a license to third parties to use. And again, license can last for a number of years. Okay, it's never perpetual. It's usually for a number of years and then it reverts back to the copyright owner again. Any other questions you wanted me to answer? Is image rights enforced in Nigeria? I don't know about Nigeria. Again, I don't practice in Nigeria. I should be asking you guys that. Is image rights enforced in Nigeria? But there again, like I said, I think the law, I do know for a fact that the law in Nigeria needs updating, is in need for updating. And I am on a case at the moment with a high profile artist in Nigeria who, yeah, I'm representing a high profile artist in Nigeria through their publisher who's based here in the UK. And we are struggling at the moment with certain piece of legislation in Nigeria, simply because in the UK it would have been easy to litigate, but in Nigeria that law doesn't exist, and the law, you know, unfortunately, well, the jurisdiction for that contract was Nigeria. So yeah.
Thank you. Thank you so much, Nosa.
Quick question, sir. Okay. Earlier you mentioned DSPs. I know I can probably research it, but I wonder if you could explain what that is.
Okay.
DSPs.
So a DSP is a digital service provider. And they're your classical Spotify, Apple Music, UdoX, Boomplay, Deezer, Tidal, anywhere you consume music digitally, okay? They are known as DSPs. It's like, you understand, that's the group name that's given to them. They're digital service providers. They provide digital services.
Thank you, sir.
You're welcome.
Thank you very much, Nosa. Thank you for taking your time to talk to us today. We really appreciate you, and we are so grateful that you stayed till the end to see that everyone is satisfied. I also like to thank Grace. Thank you so much. Despite the internet issues, you're still here. Thank you very much. And I can see from the participants that we have Regina here. Regina is from Aluko and Oyebode Fem. Thank you so much. We'd like you to just say hi before you go. And I can also see Maria Bruscato here. I would like to also say thank you for staying till the end. Thank you everyone for staying, and we hope that by next week Friday we'll be able to touch another interesting topic. I think we'll be touching blockchain and AI next week Friday. So it's interesting and it's getting sweeter and hotter. So thank you so much everyone. Have an amazing weekend.
Okay, let me just say hello. Hi, this is Regina.
So good to hear your voice, Regina.
Yes, it was an interesting discussion. I just wanted to say one or two things on the question on TikTok, the dances on social media. It says, are dances on social media handles like TikTok copyrightable? So the question here is not really whether the dance, it's whether the dance being displayed is copyrightable. So my take here is, if the dance is original and it's fixed in the, if the dance is the original work of the dancers, so they're not infringing on any existing work. So basically, it should be copyrightable in Nigeria. So unlike other jurisdictions where you need to, first of all, have approval or register your work before you enjoy copyright, in Nigeria, we know that we don't do that. So I believe that once the dance it's your original work, it's not a derivative of another person's copyright, because you can't have copyright when you are infringing on another's work. So once it's original and it's fixed in a medium, it should be copyrightable. Yeah. Thank you.
Thank you, ma'am.
Thank you very much. Thank you, Regina. So I don't know if Maria would like to say hi before we just go off. Okay. Okay, so we'll just say bye here. Thank you so much and have an amazing, and thank you to everyone who put their videos on. Thank you, Esohe. Thank you, Omotoye. Thank you, Gabriel. Thank you, Usman, and thank you, Grace. Thank you, Nosa, once more. Have an amazing weekend.
Thank you, guys.
Bye.
Thank you.
Bye.
Bye.